All right, let's dive right in. If you're a supervisor, you know that conflict is just part of the territory, right? It comes with managing people. But here's the thing that can get tricky and fast. That simple friction on your team can actually blow up into a huge legal problem for you and for the whole company. So today we're going to talk about how to manage that risk effectively. Take a look at this quote. It really hits the nail on the head. You know, those huge legal blowups, harassment claims, discrimination complaints, they don't just happen overnight. Nope. They're usually the final act in a long drama of unresolved tension and dysfunction that's been bubbling under the surface. Your job as a leader is to spot that tension and deal with it long before it ever gets close to a courtroom. So how does it happen? Well, think of it like a ladder. We call it the conflict escalation ladder. It all starts at the bottom rung with a simple disagreement, maybe about a project. But if you let it go, it can climb to the next rung, personalization. Suddenly, it's not about the work anymore. It's personal. Then it can jump to open hostility. And that final, most dangerous rung, that's legal risk. Our whole goal today is to give you the tools you need to stop the climb on those lower rungs. To get that done, we're going to break it down into 5 key areas. We'll pinpoint exactly when conflict crosses over into a legal territory. We'll define what a hostile work environment really means. We'll talk about the #1 risk supervisors face. It's called the retaliation trap. Then we'll get into your best defense, good documentation. And we'll wrap it all up with a simple checklist you can start using right away. Okay, let's tackle that first big piece. When does a simple disagreement or even just someone being rude turn into something the law actually cares about? This is the million-dollar question, isn't it? And you have to know the answer. Knowing where this line is protects your employees, it protects the company, and honestly, it protects you. This isn't about turning you into a lawyer, it's about making you a smart, effective leader. So here's a really critical distinction. The law doesn't require a perfectly polite workplace. That means things like petty slights, someone being annoying, or a one-off incident where a person is just a jerk. That's usually not illegal. The legal line into harassment gets crossed only when 2 things are true. First, the conduct has to be severe or pervasive, which means it's either really bad or it happens all the time. And second, it has to be because of a legally protected characteristic. And that second part is the clincher. The reason for the bad behavior is what matters. For it to be a legal harassment under federal law, it has to be connected to one of these things, these protected characteristics. If the conflict is about someone's race, their religion, their gender, their age, you name it from this list, that is a massive red flag. That's your cue to stop thinking of it as just a personality clash and start seeing it for what it is, a serious legal risk. Now, this idea leads us directly into one of the biggest legal claims that grows out of conflict that's left to fester, the hostile work environment. Let's break this definition down. Notice, it's about the environment, the whole atmosphere of the workplace. The key here is the reasonable person standard. It's not about whether you think it's hostile. It's about whether an objective, reasonable person would find it intimidating or abusive. That's the test. And what kinds of things create this environment? Well, it can be a whole mix of stuff. We're talking about a constant barrage of offensive jokes, slurs, threats, or just relentless mockery. It could even be offensive pictures left around. It's any behavior that becomes so pervasive, it makes people feel unsafe and keeps them from doing their jobs. Let's look at a quick case study. You might hear about this and think, they're just jokes, they don't mean anything by it. But legally, this is a huge problem. It's pervasive conduct, it's happening repeatedly, and it's based on a protected characteristic, religion. By not stepping in, you've allowed a hostile work environment to grow. And those harmless jokes, they just became Exhibit A in a lawsuit. Okay, let's shift gears to what is, without a doubt, the single biggest legal landmine for supervisors. It's not actually harassment itself, it's what you do after an employee comes to you with a concern. This is the retaliation trap. And I'm not being dramatic here. For years now, retaliation has been the #1 most common charge filed with the EEOC. That's the U.S. Equal Employment Opportunity Commission. It is by far the easiest way for managers to get themselves and their company into serious trouble. So what exactly is it? It's pretty simple, really. Retaliation is punishing someone for doing something they have a legal right to do, like complaining about harassment, being a witness in an investigation, or even just raising a concern with you. Now here's why it's a trap. Retaliation is often subtle. It's almost never as obvious as firing someone right after they complain. It's things like suddenly changing their schedule to be less convenient, forgetting to invite them to team meetings, or all of a sudden becoming hypercritical of their work. These are things a supervisor might even do without realizing it's illegal retaliation. Look at this example. Your intention might even be good. You think, hey, I'll solve this by separating them, reduce the friction. But what did you actually just do? You punish the person who spoke up by taking away a good project. That, my friends, is a textbook case of retaliation, and it's illegal, even if your heart was in the right place. So, with all these risks floating around, harassment, hostile environments, retaliation, what's your best line of defense? It's simple, clear, consistent, and factual documentation. It is your single most important shield. And the way you document is everything. Look at the difference here. Alex was aggressive. That's a subjective label. It's your opinion. But Alex raised his voice and slammed the report on the desk? Those are objective facts. That's what you saw, what you heard. Facts hold up in an investigation. Opinions just sound like bias. So, anytime you have to document a conflict, these are the must-haves. Get the basics down. Date, time, where it happened. Describe the behavior using facts. Note who else saw or heard it. And this is so important, write down what you did about it. Did you talk to the employee? Did you report it to HR? Showing you took action right away is a powerful defense. And this is exactly what happens when you don't document. This supervisor may have done all the right things. They coached, they talked to the employee, they tried to fix it, but with zero notes, there is no proof. It's like it never happened. Now the company has no record to show that the supervisor was actually doing their job. This is the one compliance reminder I want you to remember above all else. From a legal point of view, if it wasn't documented, it didn't happen, period. An unrecorded action is the same as no action at all. It's that simple and it's that serious. Okay, we have covered a ton of ground, so let's pull it all together into a final simple checklist, your go-to guide for heading off these legal risks. Here are your 5 key takeaways. 1. Get in there early while it's still just a disagreement on that bottom rung. 2. Know where that legal line is. The second a protected characteristic gets mentioned, your antenna should go way up. 3. Actively prevent retaliation. Make a clear mental separation between dealing with a complaint and managing someone's performance. 4. Document objectively. Facts, not feelings. Behaviors, not labels. And 5, this one is not optional, escalate to HR. You're not an investigator. Your job is to spot the risk and report any and all potential harassment and retaliation concerns right away. And just a quick but really important heads up here. This training is for general information. It's not a replacement for actual legal advice. When you're dealing with a real specific situation, your first call should always be to your HR department or legal counsel. They're the experts for your particular case. So as we wrap up, I want you to think about your own team. Is there a small conflict simmering right now? What's one step, just one, that you can take this week to de-escalate it before it starts climbing that ladder? Your proactive intervention is the best defense we have. Thanks for your time and attention.